All right, future legal eagles, grab your headphones because we're diving deep into the fascinating world of Rule 118 of the revised rules on criminal procedure, pre-trial. Think of this as your audio guide to mastering this crucial stage of a criminal case. Now you've all been through arraignment, you've entered your plea, and the legal battle lines are drawn. What happens next? In most criminal cases, especially those handled by the regional trial courts, the answer is pre-trial. Professor Riano, in his comprehensive work on the revised rules on criminal procedure, emphasizes that pretrial is not just a formality. It's a mandatory stage designed to streamline the proceedings and achieve a swift and just resolution. It's the court's way of saying, let's get organized before we go to full-blown trial. The core purposes of pretrial, based on Riano's discussion: expediting the trial. This is the overarching goal. Pre-trial aims to cut down on unnecessary delays and ensure that the actual trial focuses only on genuinely disputed matters, clarifying and simplifying issues. Imagine a complex case with a multitude of facts. Pre-trial helps narrow down what's truly contested and what can be agreed upon. This means less time wasted in court proving things no one disputes. Exploring possible admissions and stipulations. This is a big one. Parties are encouraged to admit facts that are not genuinely in dispute. For example, if the prosecution has a clear CCTV footage, the defense might stipulate to the fact that the accused was at a certain place at a certain time, saving the prosecution from formally presenting the footage and its authenticating witnesses during trial. This is where lawyers need express authority from their clients to enter into such agreements, as per Riano. Marking and examining the authenticity of documentary evidence. Before trial, both sides present their lists of documentary evidence. During pretrial, these are marked, and their authenticity and even admissibility can be discussed. This helps avoid surprises and objections during the trial proper. Considering the propriety of plea bargaining, this is a critical aspect, particularly highlighted in recent Supreme Court jurisprudence. Pretrial is the stage where the possibility of the accused pleading guilty to a lesser offense or to the offense charged under certain conditions is explored. The court plays a vital role here, ensuring the proposed plea bargain is consistent with law, jurisprudence, and that the rights of the accused in the interests of the state are fairly protected. Agreeing on other matters that may expedite trial. This is a catch-all provision. It can include discussing the number of witnesses, the order of presentation, or even the possibility of adopting a continuous trial schedule. The pretrial brief, your roadmap. Before the pretrial conference, both the prosecution and the defense are required to submit a pretrial brief. Think of this as your pregame strategy document. Riano emphasizes that this brief should typically include a statement of the case, briefly outlining what the case is about, facts proposed to be admitted, what you're willing to concede, proposed stipulations, joint agreements on facts or procedures, list of documentary exhibits with copies attached, your evidence ready for review, list of witnesses with a short statement on the nature or purpose of their testimony, who you're calling and what they'll say, other matters that may help expedite trial, anything else to make the process smoother. The pretrial order, the binding agreement. After the pretrial conference, the judge is mandated to issue a pretrial order. This order is incredibly important because, as Riano points out, it controls the subsequent course of the trial, unless amended to prevent manifest injustice. The pretrial order will contain the stipulations or admissions made by the parties, the issues to be tried, the actual points of contention, the evidence marked, waivers, if any, of objections to the admissibility of evidence, other relevant matters agreed upon. Any deviation from this order during trial must be properly justified. Courts are generally strict about this to maintain the integrity and efficiency of the proceedings. Key Supreme Court decisions on Rule 118. Let's look at some jurisprudence that shapes our understanding of pretrial, particularly regarding plea bargaining. Estepona, Jr. versus Labrigo, GR number 226679, August 15, 2017. This is a landmark case concerning plea bargaining, especially in drug cases. The Supreme Court declared that Section 23 of Republic Act No. 9165, the Comprehensive Dangerous Drugs Act, which previously prohibited plea bargaining in certain drug offenses, was unconstitutional. The court emphasized that plea bargaining is a rule of procedure and thus falls under the exclusive rulemaking power of the Supreme Court under the Constitution. This means the legislative branch cannot unilaterally prohibit plea bargaining. This decision breathed new life into plea bargaining as a crucial tool for decongesting dockets and promoting speedy disposition of cases. Takeaway for students. This case underscores the judiciary's constitutional independence in procedural matters. It also highlights the significance of plea bargaining as a means to achieve expeditious justice, even in serious offenses like drug cases, provided it's done within the bounds of justice and fairness. Subsequent jurisprudence building on Estepona. Following Estepona, the Supreme Court issued AM number 18-03-16-SC, Adoption of the Plea Bargaining Framework in Drugs Cases, which sets out guidelines for plea bargaining in drug cases. This framework ensures uniformity and clarifies the conditions under which plea bargaining can be allowed, considering the severity of the offense and the evidence. Takeaway for students. While plea bargaining is a procedural right, its application, especially in specific offenses like drug cases, is now guided by specific Supreme Court frameworks. You need to be familiar with these frameworks to properly advise your clients. Importance for law students. Understanding. Rule 118 is vital for several reasons. Practical application. As a future lawyer, you will be actively involved in preparing pretrial briefs, attending pretrial conferences, and making strategic decisions during this stage. Strategic advantage. A well-prepared pretrial can significantly shorten the trial process, saving time and resources for both your client and the court. It can also reveal weaknesses in the opposing side's case or opportunities for settlement. Client counseling. You need to clearly explain to your clients the implications of admissions, stipulations, and plea bargains, as these decisions can have profound effects on their case. Due process. The proper conduct of pretrial ensures due process for the accused, as it allows them to understand the issues, prepare their defense, and explore potential resolutions. In essence, Rule 118 is the unsung hero of criminal procedure. It's the stage where much of the groundwork is laid, setting the tone for the entire trial. Mastering it means you're well on your way to becoming a skilled and efficient legal practitioner. So when you hear pretrial, don't just think paperwork. Think strategy, efficiency, and the pursuit of justice. Keep studying, and I'll see you in the courtroom.